This conference will now be recorded.
The Pledge of Allegiance. I pledge allegiance to the
To the
flag
flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we'll start right out with item A. Let's see. Do we have enough people that were at that meeting to form a quorum?
I believe so, yes.
Okay. Do I hear a motion to accept the minutes from November 7th meeting?
Yeah. So moved.
Second.
All those that were here for that, all in favor?
Aye.
Aye as well. Okay, and then the regular board meetings from November 21st. Do we have enough people here for that?
Yep, I think it was everyone except Peter.
Okay.
Yeah.
Do I hear a motion to accept?
Second.
All in favor?
Aye.
Aye as well. Okay. Item C is to designate Town of North Elba as the lead agency for coordinated review of the proposed amendments to the land code in relation to short-term rentals under the State Environmental Review Act. Do I hear a motion to accept that?
I'll make the motion. Second.
All in favor?
Aye.
Aye as well. Okay, very good. And item D, anything you want to add to that, Peter, before we ask for a motion?
No, they're probably a year out, so we don't need them today, but we're going to need them in a year.
Oh, it's
Okay.
only 34 weeks. 34 weeks.
And it sounded like the bids came in lower than we hoped they would, so it's a good thing.
Well, on the submarine cable, for sure.
Very good. Okay, motion to accept.
I'll make the motion.
Second.
All in favor?
Aye.
Motion passes. And then that brings us to item E, the 15 kV submarine cable bid award. That was the one that came in lower?
Yep.
Great. Motion to accept.
So moved.
Second.
All in favor?
Aye.
Aye as well. Item F is a electric department promotion for Zach Ford. He's finished his 6-month probation, and Kimball is asking effective November 30th that he become a third-class lineman, step 2, with a pay of $27.06 per hour. Do I have a motion to approve?
I'll make the motion.
Second.
All in favor?
Aye.
Congratulations, Zach Ford.
Art, I'd also like to make note that most of the decorations have been done by Zach Ford.
Very
Most of
nice.
Yeah, and he really has done a very, very nice job.
Got the artistic touch.
Thanks to him.
Okay, and item G is the annual NICOM Winter Legislative Meeting, February 5th through 7th. Need a motion to approve that anyone on the board that would like to go, or any of the department heads.
I'll make the motion. Second.
All in favor?
Aye.
So passed. Anything else to come from clerk items today?
Just a reminder from Tracy, and this might be a first time notice for some of you. There is a pest training going on tomorrow, 9 to noon here in this room if you're available for it, or if you want to do it from your own desk, Tracy can send you a link. If you cannot make it under such short notice, there will be another one next month. So
That's good.
let me know.
Do you have the dates for next month?
I don't yet, but we probably have them. I just don't know it off the top of my head. So we'll let you know.
Yeah, that'd be great.
Sure.
Okay, so there is another training next month, so I don't have to zoom in on it. Is that right?
No, you don't.
Okay, very good. Anything else from clerk?
Do I have to do it here?
I think if you give us proof of that, then
Okay.
sure, just give us something in writing.
Your certificate of compliance.
Okay, anything else, Anita, from clerk?
No, that is all.
Okay, and under treasury items, looks like we have warrant affidavit number 8. I'm guessing Jackie reviewed them.
No.
Not this time.
Who's that?
Peter knows he'll be sad to miss it in a few months, so he did.
I was jealous of Jackie.
He must have forgotten. Actually, he really didn't do it or he didn't sign it.
Okay, you will. Motion to approve warrants?
So moved.
Second.
All in favor?
Aye.
Aye as well.
Just put in the
Anything
folder.
else from Treasury, Mindy?
All the papers.
No, not at this time.
Okay, very good. Anything under new business? Going once? Under old business? Just the notice of up and coming public hearing, December 16th and 19th, and joint board meeting, December 20th. And is there anybody else under old business? Gone.
Is that in the rink again?
No,
No.
we were gonna do it here.
Right here?
Yeah.
We're expecting a smaller crowd.
Yeah.
But the one on the 16th is just for an extension.
Right.
Our extension.
Our extension.
Okay, so I sent that out to everybody today. I left the date of how long do you want to extend for. I did not put a date in. It's up to the board to
Oh.
determine how long you think we ought to go. I
January
believe the
30th.
town is
Same as
going
the
to.
same, right?
Yeah.
I think that makes sense.
Yeah.
I agree. Okay, there is nothing to come under mayor items or any commissioner reports?
No,
Okay.
Nope.
The date just signs.
If that's the case, it doesn't look like anyone's there for public comments. Is there anyone online that would like to ask any questions? Easy crowd tonight.
I have a couple questions.
Okay,
I was hoping that you could just explain exactly what item C is.
Yes, Lauren, hi, it's Janet. So.
Hey, Janet.
Under the State Environmental Quality Review Act, where there are more than one agency or body involved, it's appropriate to appoint one agency as the lead agency. Therefore, you avoid any ambiguities in the review. So we have, or the board is designated tonight that the town of North Elba will act as lead agency for coordinated review of the amendment to the short-term rental law as required under the State Environmental Quality Review Act.
Okay. And then,
The village board will be attending the session to review or to be aware of the findings, if any, that the town makes when they go through the environmental assessment form.
is there anything
Thanks.
else, Lauren?
yes, thanks. I was hoping that you could just talk about the public hearing on the 16th and what's on the 19th, and as well as the joint board meeting on the 20th.
The public hearing on the 16th will be in conjunction with or just prior to the regular board meeting. And due to the fact that as a result of the comments that were made at the public hearing last week, there will be a revised proposed amendment to the short-term rental law. And the changes are substantial enough that it warrants a new public hearing and process. Currently, the village's short-term moratorium will expire on December 30th. The process, as you know, is for any local laws to have a public hearing, hear comments, and then change it. So we're not comfortable right now that as a result of the changes that are being made to the proposed short-term rental law, that we can accomplish everything before before December 30th. So to be proactive and just to be conservative, the public hearing on the 16th will be for a local law to extend the moratorium to January, what did you say, 31st. If necessary, of course, we can terminate it earlier, but given the process that you have to go through for any local law, we're kind of concerned that we could accomplish it all before the current deadline on the moratorium. So that's what the public hearing will be for on the 16th. And on the 19th, the public hearing on the 19th, I don't know that we're having one on the 19th.
Yeah, we are. Wait a minute. The 19th
Oh, the 19th is the one you just described.
is
Oh,
the
sorry.
secret.
Oh,
Sorry,
and the
sorry.
16th is,
The extension,
Okay,
or is it vice
the
versa?
19th is the extension.
Extension, 16th is the secret,
okay.
is the
Oh,
town.
no, that's,
No, the
that's the
16th
20th.
is the public hearing.
Oh,
Excuse me. The 16th is the public hearing on the revised proposed local law to
Okay,
amend
correct.
the short-term. The 16th is a Friday.
Yep.
So that is the public hearing. It'll be a joint public hearing with the town.
Yep.
Similar to the one that was held last week, for review of or public comment on the revisions that were made. I'm sorry, Lauren, if I confused you. The one on the 19th is for the extension of the village's moratorium.
And then on the 20th?
The joint board meeting on the 20th is with the village and the town,
That's the secret process.
which will be the seeker process that I described in response to your question with regard to item C on the agenda, Lauren. It's actually a town board meeting and the village trustees will attend. So all of this has to do with complying with and continuing the process of amending the short-term rental local law.
Okay, thank you for explaining that. Would you mind giving me the times for each hearing?
The 16th will be at 6 PM. That's the Friday night one. The 19th, should we do that just prior to our meeting at 4:45 or?
sure. Yeah.
We've done that before. So the 19th will be at 4:45, just prior to our regular meeting. And December 20th, I believe 5:30. That public notice should go out the next day or two. The public hearing for the 16th is in tomorrow's paper, and the revised law is already on the village website under meetings, if you want to see it. Revised proposed law.
Okay, thank you. That's all I had.
And Bob, it looked like you had your hand up.
Yeah, oh, yep, sorry to keep putting it up. I didn't know how it was working. Okay.
That's okay.
This is Bob DiMartino with a question regarding the definition of change in ownership that's proposed for the new short-term regulations. There's some confusion in the AFRA group as to what exactly this allows. It seems as if the death of an owner leaving a surviving joint tenants with rights of survivorship or tenant by entirety, no real property conveyances between spouses. So it sounds as if a spouse would be covered even if they are not currently a joint owner. I think they would still be able to have a permit in effect should one or the other pass away. Is that correct?
Spouse, yeah.
Well, Bob, I think I heard you say if the spouse is not currently entitled, then they are not a tenant by the entirety or ownership of a joint tenancy with right of survivorship because they have no ownership interest.
Right?
So so no, that is not covered.
Well, it says also, nor real property conveyances between spouses.
Right, so if, for example, you have two people and for whatever reason, a married couple, and for whatever reason, one spouse is conveying to the other, that's allowed under change of ownership. It does not cover death. So if one spouse is the sole owner of a piece of property and dies, that is not a change of ownership.
Okay. So that's not a change of ownership, but if a conveyance between spouses prior to death is not a change in ownership either?
If a married couple owns property currently and one spouse conveys to the other, that is not a change of ownership.
Right. Even though both may not be on the deed currently.
No, I said, currently, it would only be if two people are on the deed, a married couple is on the deed, and one conveys his or her interest to the other, that is not a change of ownership as it's currently written. But I think you're asking if there's a married couple and only one person in that couple is on the deed, what if they convey to now their spouse solely, or they want to put their spouse on the deed with them? Which is your question?
Well, I guess it doesn't affect me, but there is one member who owns a home who does not have his spouse on the deed. And his major concern is if he were to pass away and the property, if his wife was to inherit the property, would that be considered a change in ownership?
Yes, it would. As it's currently written, yes, that would be considered a change in ownership.
He's able to give her part of the property.
No, she's saying there's one person who owns the property and dies.
No, but I mean, but to insulate against that, he could transfer.
Yeah.
They
Okay.
could have joint ownership.
Well, we haven't crossed that bridge, no.
Which bridge haven't we crossed? I'm sorry.
The one where maybe a married couple, a couple is married, and at this juncture, only one of them is in ownership of the property, and they now desire to put it in both names,
Right.
or one who's entitled decides just to put it in his or her spouse's name. I don't think that's clarified as it's currently proposed.
So the fellow who has the dilemma right now, not having his wife on the deed, and is concerned about at his death, her not being able to continue to rent the property or hold the permit at any rate, he might have the possibility of adding her to it without losing his permit. Is that what I'm hearing? I shouldn't say
No,
might.
what you're hearing, what I'm saying is, I don't think that's been considered yet or really vetted under our current definition. He could, however, put his spouse on his deed now.
He could? Why now? Because before the law goes into effect? Is that it?
Because the proposed local law has not been passed yet.
Right, okay. So even now, that's not considered a change in ownership?
That's correct.
So, well, let me ask you, I have another question, but this is interesting. So if children were added to a deed, what would the effect of that be at this point in time? That's not considered a change of ownership?
I have to review that, Mr. Martino, because I'm not I haven't looked at that in the current law as it's written, so I'd hate to answer right now and give you a wrong direction.
Okay, so how can we, can I get a follow-up in some way, shape, or form? So that we'll
Sure.
have it on record? Because people are
Sure.
talking about adding children to their deeds at this point.
Yeah,
Before-
we can follow,
Before
we
the
can
new
follow-
law goes into effect.
yeah, we can follow up on that.
So then I think I now know the answer to my final question, but I'm going to ask it anyway to be sure. Okay, this goes on to say, again, neither the death of an owner leaving a surviving joint. It's basically, the neither is describing what isn't considered a change in ownership. So we just covered the conveyance between spouses, but no real property conveyance. So it says, nor real property conveyances without consideration from individuals to an entity of which the transferors or principals shall constitute changes in ownership for the purposes of land use. So what are real property conveyance? What's an example of a real property conveyance without consideration from individuals to an entity of which the transferors are principals? I'm not a lawyer, and I sure see why. So I've got to look about the second.
Let's say that you currently own your property in your individual name, and you, for whatever reason, would like to now transfer ownership of it to a trust. Some people, as part of their estate planning, for example, might set up a revocable trust. So if you wanted to change your form of ownership, for example, from yourself individually to a trust of which you are the trustor, we'll call it, without any consideration, that would be an example. Another example might be, for whatever reason, you decided instead of owning your property in the name of, in your individual name, you'd like to set up a limited liability company. And if you were the sole member of that limited liability company, you would be the principal of it. If you conveyed it from yourself individually into that limited liability company of which you are the sole member, for no consideration, that would be another example.
Okay, but it would, if I'm holding it individually or in joint tenancy with my wife, no one else would be able to be a part of that.
That's correct.
Liability. Okay,
And if, for example, you set up a limited liability company of which you were the sole member, and somewhere down the road you wanted to add members, or you transferred your ownership interest to somebody else, that would be a change of ownership.
Right. But if this this entity, which could be a trust that's described in here as from individuals to an entity, a trust is an example of that entity. That entity at this point in time could include our children, that trust. Is that correct?
Well, can include children in what capacity? If they're beneficiaries and they would take ownership of the property upon the death of the trustor, that would be a change of ownership.
It would. So, you understand the problem I'm trying to address, which is a pretty big one for a lot of the members of this group. It's essentially that their children cannot inherit the property with the permit, right?
That's correct. That would be a change in ownership.
So this change in ownership, this definition, which gave some hope to people, doesn't really cover that particular situation.
It does not cover death of the permittee.
Right. So is somewhere along the line during the meetings, and this will be my last question, I promise, there was some discussion of considering the maintaining a permit in the case of the death of an owner and the inheritance of the property by his, immediate family, children being the principal example. So is that no longer under consideration?
I can't answer that.
I would say yes, that's no longer under consideration.
In this version of the.
Right.
I'm sorry, I didn't hear that comment.
In this version of the law.
Right. Is there likely to be another version of the law? I guess.
I would say yes, there probably is likely to be another version of the law, so we're not.
Well, then that's going to require a whole nother public hearing.
No, but I mean,
Just, the plan is to keep things in review.
Okay.
I think
I mean,
our commitment was next year and then the review, who knows, right?
Yeah. Oh, I appreciate your clarity. Okay, thank you very much, the clarification. Thank you, that was it.
Is there anybody else that has any questions? Anything more from the board? Okay.
Yeah.
if that-
Meeting now?
Yeah,
I have some comments and questions. I didn't know if there was a special
one more.
meeting that you have there. I got a few things here, so be patient with me. I want to talk about the access for Wendy and ADA and this overall project that you did on the streets. Prior to the Main Street upgrade, there was a meeting held. I wrote a letter ensuring that the project would be ADA compliant. This was read at the meeting. Another woman with the local senior center made similar points about ADA. The announcement was clear from the village representatives that the project would comply with ADA during and after the project was complete. During the project, all the walkways from on the east side of the road from MBT to the post office created a non-compliant walkway and barriers to the physically disabled. I suspect this measure was done to decrease the durations for the sporting event. Andy Flynn posted a YouTube video with a condition stating the impossibilities for disabled people due to the construction methods. Last month, I notified Mayor Devlin about a non-compliant ADA condition at Miss Fletcher's gate, where the walking surface is too high, which is a barrier for her. Mayor Devlin's response was that he will get back to me with the legal response versus remediating the problem. I asked the clerk or the village ADA coordinator. She said the village does not have such a person. I then asked the mayor for the village's ADA grievance procedure, and I haven't heard a response back on that. Both of these items are required by Title II of ADA law. So the village is compelled by law that they have to have both of these in effect. So now the village is facing 3 ADA violations, and it could cost them $75,000 per violation. The U.S. Department of Justice is handling this complaint from here on out, and due to the village's avoidance to address the problem. I don't need a comment. That's just it. If you want to comment, please do. Art, comment?
I will leave that to my legal counsel. Thank you.
Very good. Legal counsel?
I have no comment, other than that we did receive your notification of non-compliance at Miss Fletcher's stairs, and it is being reviewed.
I got a few more things here. The granite pavers that were installed by the village seem to be very slippery when snowing. I walked on it the other day, and it seems like the 2 different materials that you have, or the 3 different materials, the granite is much more slipperier than the other materials. Granite is not naturally a slip resistant surface like limestone quartz. Granite requires treatment to make it more slip resistant. Mayor Devlin, you were key in picking out the granite and touring around different facilities. What specified conditions were required upon the granite to make it more slip resistant?
When you say what requirements from the grant, there were none. And everything I've heard and seen is that the granite is much less slippery than the bricks ever were. The only time the granite, in my opinion, seems to be slippery is when everything is just coated in ice and there's no way to do anything but sand and salt.
Well, I walked on it the other day and I found that not to be true with the other materials that you have there. And I'm not the only one with this complaint. 2 other people have mentioned this as well. But there are methods that you can apply to granite, one of them being flaming, which makes it the most slip-resistant surface.
You're talking about a furnace finish, and I believe these are furnace finish.
Okay.
Yeah, definitely.
Very good.
Yeah, and like I said, everybody I talk to, Mark, maybe you can specify, people that are up on Main Street day in, day out, how do you find the granite compared to the bricks?
I haven't heard any real complaints about it.
Okay. Well, it's not necessarily to the brick. We're not comparing it to brick art.
But sidewalks, whatever you want to compare it to, everyone I've talked to is very happy with it.
I've heard it from 2 other people, so be very, very careful on it. It's very slippery.
Sometimes you have to be very careful on everything in Lake Placid.
Yes, you do. There's a lot of truth to that statement. The November 21st Village Board meeting, the YouTube post is missing about 10 to 15 minutes when the Adirondack Sports Council was presenting its plan for Main Street celebration. Is that video or audio available? And I can look at it on this clock, because that clock, when I checked it when I came in, it is accurate within a minute to my clock. And when you watch that posting, it doesn't start until about 12, 14 minutes after. So is that available?
It's not available, but it wasn't that long a period, and I don't remember them.
Well, nothing what they had to say about any of the permits or any of the parking or the closures was included with that. But you can go back and look at the video, and it's different than the clock that you see. The clock is accurate right now. Meeting started at 5 o'clock. That video didn't start until 10, 12 after.
No, it started approximately 5:05. I remember that evening.
Right, so we're missing 7 minutes. There was no pledge, there was no.
Right, and I apologize for that. It was my fault for
Is there an
not.
audio recording of that meeting? Because that's key of what I'm interested in.
There is not, but they did not present at that meeting.
Okay, well, there were some things talked about with parking and the permitting process and all of that, so, all right, I guess that's lost to the interest then. Just to recap here on my interactions with the village for this closure of this event. I read in the local newspaper about the 10-day closure. I spoke to Chief Dobson about that. He told me plans were not finalized. However, the celebration organizers will have buses to various lots. I explained to him that we are in no way part of this organization or its celebrations, and we can't be compelled to their rules and regulations on hauling us to and from lots. On October 17th, they attended a meeting online, which we could listen to that right now if we'd like to. Listen to my portion of that meeting.
I don't think we have to.
Do you want to paraphrase?
Well, we could listen to the actuality. It's only a minute or two.
Thank you very much. Okay. Anybody else?
Yeah, I have a question. This is Jim Hughes. Right, Jim? Hi. Bear with me, I'm a little under the weather today, so my voice sounds a little cracky. Just be patient. I'm asking today, I wrote to the chief about the closure of the Main Street around our house for this winter event that's going to be going on in January. That being said, we're the only permanent resident that's affected by this park. Now, what's happened with this is that the park that we have is going to be removed because of the road closure.
Jim, I know, this is Janet.
Hello, Janet.
How are you? I guess you're under the weather.
Yeah.
That was a redundant question. We certainly have recognized your situation, and that is being addressed. And the chief is aware of it, and they are going to be making some sort of accommodations so that you will be able to get to your residence and park on your property. You will not be required to park in any municipal lot. The logistics of that are still being worked out, but your right to get to your single-family residence and perhaps even, I don't know if your neighbor's house will be done. The two of you are in a unique situation, and it has been recognized, and there will be accommodations made so that you can drive directly to your house and park on your own property.
All right, thank you very much. I appreciate that. It's pretty clear, is it not? And one thing in particular was that, Janet, you said my right, in which I do have a right to travel freely, and we'll get into that in just a second. So yes, you said accommodation, and you said right. I'm being accommodated, and this is my right. I have a right to travel. I know November 21st, I attended a village board meeting and was asking about this 10-day Main Street closure. It appears that Chief Chuck Dobson is my contact for the celebration. He stated that Ms. Fletcher would have an escort and that I will have to park at the upper MBT lot, which will change later. I was told I could have access to my home between 2 a.m. and 10 a.m., which is unreasonable unless I were an owl. I sleep and work during those hours. Further on, I was told that by Mayor Devlin after the meeting, that if I were in Europe, I would expect to have to walk great distance to get around. Well, we're not in Europe, and I keep my vehicle between 6 and 10 feet from my front porch. And such a statement is, I guess, short-sighted. Trustee Galvin, he told me after the meeting if I loved Lake Placid, I would do it. Which I love Lake Placid, but I don't think I should sacrifice my rights. November 29th, I attended a village board meeting workshop, and we started talking about the escorts, and this is all being done, the escorts and the closures and the permits are all being done by LP 2023, whoever they are. Don't know. I've emailed them. They're not transparent on it either, on who they are or what they are. And do they have, and how, and I've asked Mayor Devlin last time, who gives governance to these people to regulate state highways, village roads, village parking? You guys can't assign away my rights to the state highway. There's time, place, and manner. Sure, we can place restrictions on certain things, such as the one lane going south. But you can't assign all this to somebody else to let them decide what I get, where I go. Got a question too about all the data collected by this organization. What are they going to do with it? It seems like the trustee was able to find my information in 10 seconds the other day when I asked for it, and she pulled it right up. Why are we giving it?
I'm not a trustee, I'm the treasurer.
Oh, treasurer, I'm sorry.
So I have access to
Yes, you do.
your
And that's
information.
perfectly fine. I'm fine with that. I'm fine with Chuck having that, you having that, validating all of us. That's not a problem. But we're letting an outside organization, what are they going to do with this data? We're handing all this data over to them. And what are they going to do with it? So that's the questions I'd like to know. And they can run background checks on everybody that they get information for. Where Chuck can't do that in his department. He's compelled by law, he can't do that. But they've got this company, Best Garda, which is part of World Garda, or Garda World Security Services. They're going to take all this and they're going to run every application that they get. And they're going to do security background checks on everybody. That's my opinion. That's what I think is going to happen. And I don't see the need for us to reach outside of the village when you can collect this information quickly out of the 150 people that are going to be doing this stuff. I was told that night that the upper MBT parking lot may not be a guaranteed space for me. And that I could park as well at the marina, and I could park at on the other side of Mirror Lake or at the horse show grounds. The snow management management of the parking lots could theoretically encase my vehicle with snow after they plow it, where I would have to be required to shovel my vehicle out. Trustee Holderright said that night that the New York State Perm 33C was approved earlier that day. On December 1st, I met with Chuck Dobson to review this permit. He presented me a form that was not approved or signed off on by the New York State DOT. So does it in fact exist? I don't know. One of the conditions within New York State Perm 33C on page 4, bullet point 8, under legal, it says the privilege granted by this permission does not authorize any infringement of federal, state, local laws or regulations. I claim that being denied free travel to and from my home for both commerce and just general travel is a violation of my civil liberties. I'm being excluded by design of the government as an individual person that is only impacted by these requirements. This fundamental liberty cannot be removed without due process. In Williams versus Fears, 1900, no doubt the right of locomotion, the right to remove from one place to another according to one's inclination is attributed to a personal liberty. And the right ordinarily of free transit from and through a territory of any state is a right secured by the 14th Amendment and other provisions in the Constitution, and so as to be the right to contract, meaning work. The liberty of which the deprivation without due process of law is forbidden. And B, in Kent versus Dulles, 1958, the Supreme Court held that the right to travel is part of a liberty which a citizen cannot be deprived without due process under the Fifth Amendment. And if we're looking at this being a non-enumerated right, Richmond Newspapers v. Richmond, 1980, the court held that certain unarticulated rights were implicit in enumeration guaranteed and were often indispensable to the enjoyment of the implicitly defined rights. So meaning that these rights exist, right to travel exists, right of things that aren't specifically enumerated in the Constitution exist. Janet, you know that. So now we're left with 4 different options. What do you guys want to do? I mean, it's hard to dance around. I write letters to you, Art. I used to write them to Craig on certain things. You guys never respond to me and never reply. You throw it to your legal. But quite frankly, that's lousy representation by a government official. You should be proactive, not reactive and looking for a lawsuit all the time. So here,
I think when you make your statements, you make a lot of assumptions. You make an assumption like I'm looking for a lawsuit. I feel the other way around, and that's quite often why I do throw it to my legal counsel. So at this point, I'm still waiting for an answer from legal counsel, and as soon as I have one, like I told you in the last meeting, I will check and I will get back to you, but I have not gotten that answer yet.
but that's one item. So what do you want? What do you want to do? Do you want to provide me with access? It comes down to that. Or are you going to have me jump all over to? And I'm not doing that. I've come here. If I wanted to litigate with you, Art, I would have sat in the weeds until 2 weeks before your event was going to happen, and then I would go to the DOT and I'd say that you're infringing my rights. And I would put an injunction upon your whole organization, this whole event, and you'd have had to go answer that. Everybody would have jumped through hoops. I told Chuck that the other day. That's not what I've been down here 3 or 4 times now trying to work through this stuff. And each time I come down, quite frankly, I get a shittier deal than the last time I came down. So I was supposed to have access. Now I'm not. Now I was supposed to have access to the NBT upper lot. Now I don't. It's like, well, you can park at the horse show grounds. I travel for work. I don't want to be humping in from a flight from Montreal, come down here, park at the horse show grounds. Hopefully there's a bus to pull me out of there at 11 or 12 o'clock at night. That's unreasonable.
As I said to you before, as soon as I get an answer from legal counsel, we'll do what is legally right.
That's on the other stuff. We're not talking about that. You told me the legal counsel stuff is on the other stuff.
Mr. Hughes, you mentioned 4 options. What are those 4 options that you're?
4 options, provide me with the access.
That's one.
Yeah, so the same access that Fletcher has. Okay, if not, you can compensate me for the 12 days that we're gonna have to be gone because Wendy can't be here by herself. At the similar value of any short-term, compensate me at the short-term rental rate, which is about $1,200 a night, and pay us GSA schedule for per diem. So do you want that as an option? I mean, that's an expensive option. Your closures make our home non-marketable as a short-term rental. So I can't go out on the open market to tell somebody, yeah, you might have to park down at the marina, you might have to park down at the horseshoe or horse show lot or wherever and try to get your way to our house, but you can't bring your baggage in. So it's not that. We're trying to work this out with you guys. But every time, like I said, the deal keeps getting worse every time I come down. Almost like it's punitive.
So that's not.
Okay, that's number 2, okay?
Yep.
Number 3 is I can, like I said before, I could go in and I can work to have your permit revoked because it's not compliant. And I'm being transparent here. I'm not doing this on the trying to find a way to screw people over here. Being very transparent. And number 4, you can have due process served upon me. Take me to federal court because I'm traveling state to state. And actually, I'll be across the border too. So you can take me to a federal court and say that I have no liberty to travel during those times, for those 12 days. Because at this point, I don't have enough faith in what you guys can do around, or would stay up here at that point. During that time, I don't have enough faith where I would even be comfortable being here, or even be comfortable finding a way back. I might be walking with luggage coming back from a trip from either the marina or the horse show grounds at 11 o'clock at night. I'd have to bring special gear to pack up and come back home and walk through the frigid cold air in January up here. I have to have boots, everything else with me. So those are the options. What do you guys want to do? Let's be reasonable here. I'm tired of this. I'm tired of constantly having to, go through all these gymnastics with you folks. I deal with other people. I deal with governments. I deal with all kinds of people. Nobody's as unreasonable as you folks are, it seems like, on some of these things. Why did my deal get worse than what you offered, Janet? Why is that? Look, answer me that question.
I didn't give you specifics. I said access would be provided.
You said right, and you said my neighbor. And you said, we can parse through that if you want. You want to go through that? You want to go through that process? Come on.
You can twist my words any way you
Your
want.
words are very plain, Janet. They're very plain and they're very clear, and that's why I played them.
Okay, thank you.
You said right, and you said accommodation. You didn't say 2 o'clock in the morning. That's not accommodating. Are you up at 2 a.m.?
Not most nights.
Hopefully not tonight. Neither one of us will be. I know that.
True.
But I'm trying to work with you guys here. Trying to be pleasant, trying to let you know what's going on. You guys don't do anything with this. Aren't you going to send people down there to fix Wendy's access? That would have been a very simple process. And
Janet, are you ready at this time to answer any of its questions, or do you need more time?
Art, we've reached out to learn a little bit more about ADA. It's not a specialty that we have in-house.
Very good. Yeah, as I said before, Jim, as soon as we have answers, we'll be back to you.
But Art, you could pick up the phone, you could call me, you could send me an email. Hey, this is what we're doing. I got your notice. Communicate with me. You don't do anything. You just say that, oh, you're gonna reach out to legal counsel, but communicate. Not to pin yourself down to anything. Hey, this is what we're working on right now. And that's an easy thing to do.
Obviously, the things we're working on are the things that you've asked us, and everything you tell me what your rights are, you make your demands, you tell me if you don't know in 24 hours. Villages don't work that way. I have to get legal answers, and I'll get them as soon as I can, and when I do, I'll be back to you.
Yeah, rights. I shouldn't have to articulate my rights every time I'm speaking with you.
Every right is open to interpretation, and that's what we're getting to make sure you've got your rights.
All right.
And as soon as I get answers, you'll get answers.
Very good.
Is there anything else?
Not for me. Thank you very much. And I'm sorry if I'm emotional about this, but I just sit and listen to Wendy cry for all of Saturday because of all of this stuff with she couldn't get out. So it's very emotional to me. And I don't know if you sat ever with your wife and had her cry, for a couple hours. It's very upsetting. So I don't wish that on anyone.
Is there anything else to come before the board tonight? If not, I'll ask for a motion to adjourn.
I'll make the motion.
Second.
All in favor?
Aye.
Thank you very much for your time.
Thanks, Art.